Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And the content that I'm about to show you is breaking out of the Eighth Circuit. The SAPA has received a ruling. You know, the Second Amendment protection area that Missouri was doing. It's something that you're going to need to see. Everything will be linked into the description box below. I can't wait to hear what you guys think in the comments field. And of course, make sure you hit that like button, subscribe to the channel, turn the notification bell on, because we have some freedom to spread, and we cannot be having these gun controllers have victory. So make sure that bad boy is on. And speaking of not letting the gun controllers have any victories, we are launching a brand new shirt, and I could not be more excited. Don't let Kamikaze Kamala get in the way. I mean, you talk about a timely shirt with the election coming up. You've got this amazing World War II vibe with kamikaze pilots crashing into the ship of America. It could not be more perfect. We have long sleeve shirts. We have short sleeve shirts. We have hoodies, men's and women's. Make sure you get one. It is a limited time design. It is right down there in the description box. And again, guys, come on. I'm proud of this one, and I can't wait to hear what you guys think. And do not miss your chance, because the first orders obviously get shipped out first. But with that said, let's get into this. I've got to show you what's happening in the state of Missouri through the Eighth Circuit. So I'm going to walk you through the Firearms Policy Coalition post. Then I'm going to walk you through the actual documentation, and I'm going to show you what FPC highlighted after that. Okay, so we're going to kind of bounce around real quickly. But here's the post, happened about an hour ago. The Eighth Circuit today upheld the ruling that struck down Missouri's Second Amendment Preservation Act, saying that states are allowed to stop using their resources to assist with enforcing federal laws, but not for the reason Missouri stated. Okay, again, they're going to hit that in 1 second. Bottom line, they basically upheld the ruling that struck down the SAPA. So the SAPA is still in negative no-go territory, okay? Let me show you what the actual ruling was, because this will not only remind you what the SAPA was, but it'll show you where their heads are at. All right, so as you can see right here, this is for the Eighth Circuit. Again, everything is linked right underneath the t-shirt description right down there. You've got everybody you need to see. You got Andrew Bailey, the Attorney General of Missouri. You've got all the different players, FPC, Gun Owners of America, and then you have our opponents, the people who are the, ones in the kamikaze plane. Brady's Center to Prevent Gun Violence, Every Town for Gun Safety, March for Our Lives, Giffords Law Center, the who's who. So it's really stacking up to be quite the gun control versus gun rights. But this is the summation that they put forward, okay? I'm just kind of scrolling down. This is the appeal, because earlier courts, or earlier, good Lord, right word, whatever, lower courts, there we go. Lower courts refused SAPA for Missouri. So here's what it was. Missouri's Second Amendment Preservation Act classifies various federal laws regulating firearms as infringements on the people's right to keep and bear arms as guaranteed by the Second Amendment of the Constitution of the United States. In Article 1, Section 23 of the Constitution of Missouri, quote, "The Act declares these federal laws are invalid to the state, shall not be recognized as by the state, and shall specifically be rejected by the state." It's all constitutional. It does infringe upon the Second Amendment, not having the SAPA, all the things the Biden administration was trying to do, because that's where this originated. But again, listen to what they said here. The United States sued the state of Missouri, the governor and the attorney general, alleging the act violates the supremacy clause of the Constitution of the United States. The district court denied Missouri's motions to dismiss for lack of standing and failure to state a claim, granted in the motion of the United States for summary judgment. Okay, basically, the DOJ sued Missouri for not enforcing federal laws. Oh, I don't know, what does that sound like? Oh man, that sounds like something that rhymes with schmimishration or immigration, because sanctuary cities, those are perfectly fine. You don't have to enforce the federal laws on those. That is so passe. That's not cool. That's mean. That's absolutely mean. But if you're going to do it for the Second Amendment, oh my goodness, do you want all the children to die? All the children? Yeah. All right, let's keep going, because you guys know how I feel about this. Let me show you some of the details through these little points, again, of what it would have done. This is what they said, they confirmed can't be allowed. The following federal acts, laws, executive orders, administrative orders, rules, and regulations shall be considered infringement on the people's right to keep and bear arms as guaranteed by the Second Amendment of the Constitution of the United States and Section 23 of the Constitution of Missouri, which the borders of the state including are not limited to. Here, these are the points that they said. This is what they said they cannot have. Any tax, levy, fee, or stamp imposed on firearms, firearm accessories, or ammunition not common to all other goods and services that might reasonably be expected to create a chilling effect on the purchase or ownership of those items by law-abiding citizens. I mean, that sounds pretty within their realm in purview. 2, any registration or tracking of firearms, firearm accessories, or ammunition. So again, this is what they're trying to stop in the SAPA. 3, Any registration or tracking of the ownership of firearms, firearm accessories, or ammunition. Again, pretty solid. 4. Any act forbidding the possession, ownership, use, or transfer of a firearm, firearm accessory, or ammunition by law-abiding citizens. So that's database transferring. And finally, number 5, an act ordering the confiscation of firearms, firearm accessories, or ammunition from law-abiding citizens. Yeah, I mean, that all these sound pretty tasty. Again, that's what it was going to do, but the courts just reaffirmed the striking of it down. And I'm talking to some people to potentially give some more insight on this, so bear with me. But let me jump right down to the conclusion. I'm going to fly on this real quick. Sorry if it makes you dizzy. But here we go, right on down here. As you can see in the very bottom, the judgment of the district court is affirmed. So basically, they're saying that, hey, yeah, the lower court was just fine. It made total sense. Go team. All right. Now let's jump right back over to the FPC because, again, remember, this is the part that they highlighted specifically of this decision, again, saying the states are allowed to stop using their resources to assist with enforcing federal laws, but not for the reasons Missouri stated. And this is what they hit. And let me adjust this a little bit on my side because I want to make sure that I get everything exactly right for you. Pop it up a little bit right here. There we go. Here we go. Check this out. Second, Missouri contends that the act is constitutional because the state may constitutionally withdraw the authority of state officers to enforce federal law. The state argues that the reason why it withdrew its authority because of state-declared federal law invalid is immaterial. Keep in mind the sanctuary cities, okay? Bad for sanctuary for guns, good and okay for sanctuary cities for immigration. Again, I should really want to put that up there on the forefront. That Missouri may lawfully withhold its assistance from federal law enforcement, however, does not mean that the state may do so by purporting to invalidate federal law. In this context, as in others, the Constitution is concerned with means as well as ends. Again, you see where this is going? That's what FPC was saying. It's not what they did, it's how they did it. Okay, let's keep going here. Missouri has the power to withhold state assistance. Quote, but the means it uses to achieve it, its ends, must be consistent with the letter and the spirit of the Constitution. Missouri's assertion that federal laws regulating firearms are invalid to the state is inconsistent with both. If the state prefers as a matter of policy to discontinue assistance with the enforcement of valid federal firearms laws, then it may do so by other means that are lawful and assume political accountability for that decision. So what they just said was, yeah, if you want to avoid or discontinue assistance with valid federal firearms laws, then that's fine. But because you said they're invalid, then they're valid. What? Okay, again, please see shirt that I just designed. Here you go. Let me turn it around over for you. Please see shirt. Koala? America? Good Lord! You cannot make this stuff up. Okay, again, just to recap this for you, I'm going to go big screen so we can have a relationship again. The 8th Circuit just decided that, no, you have the power to do everything and not enforce your completely valid laws that are passed, but you called them invalid. So, but because you called them invalid, therefore they can't be not enforced. But if you call them valid, then you cannot enforce them. Guys, I swear, sometimes it just makes the eyes want to pop out of your brain. It does. But luckily, we are here together. That is the breaking news. SAPA has been reaffirmed. Next stop would be SCOTUS if it goes that way. Let's see where it goes. I'm going to talk to some people, hopefully have some great updates for you, and I will see you on the next one. I'm Braden. See you later.